All right. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
I didn't hear Miss Little. I'm sorry.
Susan, you're muted.
Sorry, yes, I swear.
Thank you. And I have some exhibits here. I have exhibits 1 through 4. I'm not sure whose exhibits these are, though.
They should be mine, Judge.
Okay. So,
We submitted exhibits 1 through 13, Your Honor.
They submitted their exhibits really late, Judge, and yesterday I emailed Judge Lee that I had some objections to 2 of their exhibits, but I think Judge was busy all day.
They
Okay.
weren't late, Your Honor. They were 1 week before. They went to counsel 1 week before the trial.
They were late, Judge, in that they did not submit their exhibits like the court instructed us for the exhibit conference, and that's why we couldn't talk about it at the exhibit conference.
And I can give you the background on that, Your Honor. I was never emailed about the exhibit conference, and it was never officially scheduled, and we still gave our exhibits to Ms. Olvera 1 week prior to trial.
Judge,
hold on 1 second. Were exhibits submitted during the exhibit conference?
they were not,
They
Judge.
were, there was never an exhibit conference scheduled with my office, Judge.
There was an exhibit conference, Judge. The court sent us out an email.
The court did not send my office an email, Judge. It went to my client. It was not passed along to me until, which took place, I believe, on Tuesday of last week, the 11th. We, at that time, my associate did join that conference and explain this to Judge Lee, and we submitted all of our exhibits the next day to Ms. Olvera.
Okay. I see. I have an email that has, no, that's not you. Hold on. I don't have that email. Could you forward that to me? My court reporter is getting ready to forward me the exhibits that Judge Lee sent.
Judge, we sent our exhibits to Ms. Olvera last Wednesday. She didn't respond to them. She did file her motion to withdraw. She responded to them Tuesday at 3 a.m. With objections to 2 of those exhibits, which were brought to Judge Lee's attention, and we didn't get a ruling on those 2 exhibits from Judge Lee prior to now.
Judge, I got their exhibits and they were emailing Judge Lee this week. It's not for me to tell them about their exhibit conference, Judge. The email went out to Miss Little, and she has changed so many attorneys. I would expect that that's the reason there was some confusion about where to send the email.
Okay, so
I'm clearly counsel of record, and it didn't go to me.
you all don't have to go back and forth. I received exhibits from my court reporter that were sent to her on Monday. Which exhibits, Attorney Olvera, are you objecting to?
I'm objecting to Exhibit 13 and Exhibit 10.
All right, I'm looking at Exhibit 13. Hold on, it's loading. It wouldn't download. Let me try to download it this way. Counsel, would you share your screen with Exhibit 13? It's not allowing me to download it.
Sure, Your Honor. Do you see it, Your Honor?
Yes, I can. Attorney O'Vera, what is your objection to this exhibit?
Hearsay, Judge, there is no authentication. I don't know where they got it. I don't know if it's correct or if it's something that their client created.
All right, what is Exhibit 13, counsel?
Your Honor, this is the website for the purported source of income from the petitioner in this case. Now, it may be a moot point because all they've provided are pay records from this business, Busby Quarter Horses, which is a Texas business. But they're also saying he lives in Australia. So he may no longer be receiving any income from Busby, but this is their website.
Okay.
Website.
So the objection is sustained. So 13 is out. What's the other one?
It's exhibit number 10, Judge.
Okay, counsel, would you pull up Exhibit 10?
This is Venmo records from Mr. Jukes.
All right, Attorney O'Vera, what's the objection?
Judge, I don't know exactly how they got my client's Venmo, but the dates predate the final order that we are trying to modify.
All right, could you pull up those dates again, counsel? Go back to. All right, and the final judgment was entered.
April of 2024, Judge.
Okay, sustained.
And I will point out that one of Mrs. Olvera's 4 exhibits is a 1099 from 2023. So it should be kept out, Your Honor. That should be kept out too.
Judge, it's too late. When we appeared at the exhibit conference, his associate, Ms. Downing, said she had no objections to my exhibits, and the court admitted the exhibits.
Yeah, so which exhibit was that again? 10?
Correct.
I sustained the objection for Exhibit 10, and Attorney O'Vera's exhibits were already pre-admitted. So those are already in evidence. So petitioner's exhibits 1 through 9 are admitted.
As well as 11 and 12, Your Honor.
11 and 12 are admitted. I'm trying to see, was that the total number of exhibits? Yes, okay. And then respondents exhibits 1 through 4 are admitted. All right. So you all have 10 minutes per side. Attorney, am I saying this right? Is it Rewalk?
Rewalk, yes, Your Honor. Very good.
Okay. Attorney Rewalk, if you would like to make an opening statement, you may proceed.
Thank you, Your Honor. This case was filed in May 21 of 2024, around 1 month after the prior order was entered. They've never shown a change of circumstance. They've never amended their pleading. We don't think the court should entertain this request at all. Just as importantly, Your Honor, we served discovery on Mr. Jukes. We got not one single document of income records of any sort from 2025. He didn't answer interrogatories, even though we served interrogatories on him. What we were served with was an unsigned interrogatory response that the court shouldn't take into account. But if the court did take it into account, he did not answer any of the questions regarding his current employer and claims that he's now been in Australia without even saying where in Australia he is. We have an outstanding enforcement on child support. He hasn't paid in years. He owes tens of thousands of dollars, and we can't even get served with that. So here he is, not paying anything, not giving us information, asking for his child supports to be lowered. And I think that's preposterous, and we're ready to proceed.
Thank you, counsel. Attorney O'Vera?
Does the opening count against our 10 minutes, Judge?
Yes.
Okay, I will waive opening, Judge.
Okay, Attorney Dale?
State waives opening.
All right. Attorney Rewalk, you may call your first witness.
I think we're the movements, Judge. Can I?
Oh, I have it. I'm sorry. I have your timers flipped. Okay, let me move them so I can put you in the movements place. Okay. Attorney O'Vera, you may call your first witness.
Judge, I'm gonna call my client Robert Jukes.
Okay, go ahead.
Mr. Jukes, state your full name for the court.
Robert Stephen Dukes.
And you are the respondent, the person that is required to pay child support in this case, correct?
Correct.
Now I'm showing you what has been marked as Exhibit 4. This is your order that sets up your conservatorship, access, possession, and child support, correct?
Correct.
And this hearing for this order was had on April the 19th of 2024, correct?
Correct.
You were not present at that hearing, correct?
Correct.
Do you have any idea what the court used or what mom presented to the court to calculate your child support in this order?
Objection, calling for speculation.
I'm asking him if he knows, Judge.
He just said he wasn't there. How could he possibly?
The question was, do you have any idea what the court used of what mom presented to the court to calculate your child support? He can answer that. Overrule.
I do not.
Okay, so Mr. Jukes, you understand that in that prior order, you were ordered to pay $1,472 per month beginning May the 1st of 2024, correct?
Correct.
And since we filed the petition to modify, we've had a hearing on temporary orders, correct?
Correct.
And the court at that time lowered your child support, correct?
Correct.
Do you know what is the exact amount that you're supposed to be paying right now?
Objection, calling for a legal conclusion.
Overrule.
I do not off the top of my head.
It's a little bit over $1,000, correct?
Object to leading, Your Honor.
Sustained, don't lead.
Mr. Jukes, do you remember the hearing on the temporary orders?
Yes.
Do you remember the information that you presented to the court to calculate your child support?
Yes.
Do you remember how much money you were making at the time of the hearing on the temporary orders?
Roughly around $90,000 before taxes.
Okay, and you prepared or you provided some 1099 forms from 2023 and 2024, correct?
Correct.
And I'm going to show you what is marked as Exhibit 1. That is your 2024 1099 form, correct?
Correct.
And this is for Busby Quarter Horse, correct?
Correct.
And Exhibit 2 is your 1099 for 2023, correct?
Correct.
And both of these years you earned a little bit over $80,000 with Busby, correct?
Correct.
Now, at the hearing on the temporary orders, you did admit to the court that you were making a little bit of extra money with some side jobs, correct?
Correct.
At that time, how much were you making on the side jobs?
At the most, an extra $20,000 annually.
Okay, so all in all, maybe about 100,000 or a little bit over, correct?
Correct.
Now, aside from this child that you have with Miss Little, you testified at the temporary orders that you had two additional children, correct?
Correct.
Are those children still minors?
Yes, they are.
How old are they?
My daughter is 16 and my son is 12.
And are those kids from your prior marriage?
Yes.
And are you obligated to pay child support for those children?
I'm not obligated, but I
You-
have an agreement with my ex-wife.
Okay, are you paying support or helping your ex-wife with those children?
Yes.
Okay, so sir, as we sit here today, are you still employed with Busby Quarter Horse?
I am not.
When did you move back to Australia?
I moved back to Australia at the end of April this year, 2025.
Explain to the court why you moved back to Australia.
My primary reason moving home was because my mother had some pretty serious health issues. I also had some health issues of my own, which I couldn't afford to take care of that in the United States. So I moved back to Australia where I have free healthcare over here and took care of my health issues.
Okay, and now that you have taken care of your health issues, are you back to work?
I just started back to work on October of this year.
Are you still doing the same kind of work that you were doing for Busby?
I am.
And if you had an estimate of how much you're making right now, how much do you make per month?
I object to this, Your Honor. We've asked for these records in discovery. They were not provided, and under the best evidence rule, I object to this question.
Judge, he has no documents. He's self-employed.
Okay, overrule, I'll allow it.
Mr. Jukes?
As of right now, I'm making around $5,000 a month.
Are you starting up your business again over there in Australia?
I am.
And tell the court what it is you do for a living.
I am a professional farrier and I provide hoof care to horses.
Okay, so since you started your business recently, Mr. Jukes, what is your estimate as to how much time it might take you to get back to earning about 90,000 a year?
It's going to take at least 12 months before I get back to where I was in the States.
Okay, and you're asking the court to lower your child support from the prior order, is that correct?
Correct.
And if the court will set it at what you're making right now, actually, we provided to the court our child support calculations based on what you're making right now, correct?
Correct.
And I'm going to show you what I've marked as Exhibit 3. That is the calculations based on an estimate of you making approximately 80,000 a year, correct?
Correct.
And giving you credit for the medical support and your 2 other children, your child support should be somewhere around 862, correct?
Correct.
Are you asking the court to set your child support at that amount?
Yes.
And if the court will not lower it to the 862, you would like the court to leave it at the amount that the temporary order set it at, correct?
Correct.
Okay, I'll pass the witness, Judge.
All right. Attorney Rewalk.
Mr. Jukes, you haven't paid child support at all in this case in months, correct?
Objection
Correct.
to relevance, Judge.
Let me read the question back. You haven't paid child support at all in this case in months. Counsel, how's that not relevant?
Judge, that has to do with the arrears, not the current child support going forward.
Okay, Attorney Rewalk, would you rephrase your question?
When's the last time you paid child support for the benefit of Holland?
I believe it was April or May of this year.
And how much was that?
I can't remember off the top of my head, honestly.
You provided as actual zero documents whatsoever regarding any of your 2025 income and discovery, isn't that right?
I did provide documents.
When did you provide those documents?
I provided them. I sent all my 1099 is my total of all of my income.
And that was for 2024, wasn't it?
And 2025, I believe.
How could you have a 2025 W-2 or 1099 when we're not at the end of the year yet?
Well, I didn't leave the States until May.
You haven't provided any income or even bank documents for 2025 at all, isn't that correct?
Asked and answered,
I don't-
Judge.
Sustain.
I added the question about bank account, Your Honor. It wasn't the same question.
Okay, rephrase the question or ask the question again.
My Zoom just froze. Is everyone still there?
Yep.
Okay, thank you. I'll screen share.
Yes, go ahead.
Sir, you never answered interrogatories in this case, did you?
Could you repeat that? Sorry.
You never answered interrogatories in this case, did you? Sir,
No.
please answer the question.
No,
This is what your attorney sent labeled as Exhibit 5, and you did not sign or have notarized this document, correct?
correct.
And you also refused to answer what your current employer, what any of your employers have been.
Objection, Judge, to the misstatement.
Let me see the question. You refuse to answer what your current employer have been. And the objection is misstatement?
It's a misstatement of the document unless he wants to point out where he refused to answer.
Sustain, rephrase.
Hold on, Your Honor. I want everyone to take your word as to what you're making now without any documents whatsoever to back it up, correct?
Yeah,
And you think that that's okay considering you haven't paid child support at all by your own testimony in the last 6 months, correct?
correct.
You also sell tools on the side, don't you?
I have in the past, yes.
And you also have judged competitions and entered competitions and won money in the past, correct?
Correct.
And now you're claiming that you don't do those things anymore, correct?
No, I'm not claiming that.
Okay, so you're intentionally avoiding making that additional money that could go to child support, correct?
No,
You could be doing those things, can't you? And you're
I
not.
I could be doing a lot of things, mate.
Objection, non-responsive.
Sustain.
You could be doing competitions and judging competitions, but you're not, correct?
Not at the moment, no.
In addition to competitions and selling tools, you also did horseshoeing on the side while you worked at Busby, correct?
Horseshoeing's my primary source of income.
In addition to Busby, you had additional income besides just selling tools, correct?
Not in the last since 2023, Busby Quarter Horses was my only client.
Objection, non-responsive.
Sustained after no.
I'll pass the witness.
All right. Rewalk, you have 4 minutes and 59 seconds. Attorney O'Vera, you have 3 minutes and 5 seconds. Attorney Dale?
Mr. Jukes, it's your testimony that before you moved back to Australia, you were making around $100,000 as a 1099 employee. Is that correct?
Yes,
Okay. And about 80,000 of that was your primary source of income, and 20,000 of that, per your testimony, was side income, other jobs, correct?
correct.
Okay. The about $7,489 that you and your attorney suggested that you would be making within the next year or 12 months. Does that include any of the side jobs or secondary work?
Correct.
It does include that amount?
It does include, yes.
Okay. I'll pass the witness.
All right. Attorney O'Vera, any redirect?
And just briefly, Judge.
Go ahead.
So Mr. Jukes, all of the extra income you have not hidden, is that correct?
No,
When Judge Lee asked you, you answered honestly, correct?
absolutely.
And even taking that into account, your child support lowered to about $1,025, correct?
Correct.
Now, you said that you're going to get up to the same amount that you were making here in the United States, maybe in about 6 to 8 months over there in Australia, correct?
Correct.
Do you have any idea or any leads on getting the extra work or the extra income like you were making here in the United States?
I do.
Okay. Do you expect to make that extra income in Australia like you made it here?
Yes,
But as of right now, your testimony is you're only making $5,000 a month, correct?
correct.
And the last 6 months, you didn't have any income, correct?
No,
I'll pass the witness, Judge.
right. Anything further for this witness?
Yes, Your Honor.
Okay, go ahead.
Mr. Jukes, your 1099 for 1024, sorry, for 2024 actually said a little over 89,000, correct?
Correct.
So to add 20,000 to that makes it about 109,000, doesn't it?
Correct.
What is your address?
Is 1618 Tullong Road, Middlebrook.
What's the rest of it?
Hold on.
Scone, New South Wales, Australia.
Mr. Jukes, did you say 1618 or 1619?
161A.
Thank you.
You said Talon Road.
Tullong, Tullong, or sorry, Tullong,
Middlebrook,
Middlebrook,
New South Wales,
New South Wales.
Pennsylvania.
All right. Okay. Attorney Olvera, you may call your next witness.
Judge, I don't have any other witnesses.
Okay, so you rest.
Yes.
Okay, Attorney Rerock.
I'd like to call Susan Little.
All right.
State your name for the record, please.
Susan Little.
And you're Holland's mother, correct?
Yes.
And Robert is Holland's father.
Yes.
When's the last time he saw Holland?
Never.
Objection, Judge, to relevance.
Counsel, what's the relevance?
I'll move on, Your Honor.
Okay, sustain.
What do you believe he is behind in paying child support to you?
I believe it's like 90,000.
And you are aware he's asking to reduce child support, correct?
Correct.
Okay. And you're asking that that be denied, correct?
Correct.
Okay. And according to your summary of relief, you're also asking for a finding that he be intentionally underemployed. Is that right?
Correct.
Okay. And you're also asking for attorney's fees in this case. Is that also correct?
Yes.
What other sources of income beyond his normal job do you recall Mr. Jukes having in your experience with him?
Objection, Judge, if that predates the last order.
Would you like to take her under voir dire, counsel?
Sure, Judge.
Go ahead.
Ms. Little, when was the last time you spoke to Mr. Jukes? In person?
2023.
Okay. Judge, I'm going to object that whatever she's going to testify about predates the last order.
Sustain.
You asked for documents from Mr. Jukes in discovery, correct?
Yes.
And he didn't provide a single bank statement beyond June of 2024, correct?
Correct.
He didn't provide a single record regarding income for the entire year of 2025, correct?
Correct.
You just heard him testify that he didn't move to Australia until April of 2025, correct?
Correct.
Did you get any income information from him from the period of time between January and April of 2025?
No.
And you served interrogatories on Mr. Jukes, correct?
Yes, I believe 3 or 4 times.
Okay. And you asked about his employers in those interrogatories, correct?
Yes.
And he refused to even sign his answers to interrogatories. Is that right?
Objection to the misstatement.
Not misstatement. He testified himself he didn't sign the interrogatories, Your Honor.
The question.
Didn't sign, but the question you said he refused to sign. So sustain, rephrase.
He wouldn't sign them, correct?
It's not signed.
Okay. You know where he worked between January and April of 2025?
No.
Okay. And in your experience, when he worked at Busby, how many days a week did he work, if you know?
Objection,
2.
objection, Judge. She has no personal knowledge.
I do have personal knowledge. We were dating at the time,
Objection,
and
Judge.
he's admitted it into another.
Judge, I'm gonna
another
object to
hearing.
her statements.
Hold on one second, Ms. Little. My court reporter cannot take down when each of you are speaking at the same time. So the question was, and in your experience, when he worked at Busby, how many days a week did he work, if you know?
2.
So her response was 2. Attorney O'Vera, would you like to take her on the voir dire?
Yes, Judge.
Go ahead.
You're basing your answers for what period of time, Ms. Little?
He testified at the end that he worked 2
Objection,
days a week.
non-responsive.
Sustained. The question was, Ms. Little, you're basing your answers off what period of time?
The time we dated and up until 2025, I guess. Yeah, up until 2025.
Up until 2025, you knew how often he was working with Busby?
He
Is
worked
that-
there
that's a
for,
yes?
yes. Yes.
Yes. And how do you know that, ma'am?
Well, he told me, for one.
You just finished telling the court you haven't had any communication with him since 2023.
Well, it
Is
was
that
2024. That's correct, but it was 2024.
Objection, Judge, non-responsive after that's correct.
Sustained.
And I'm
What
gonna
is-
object, Judge, because her answer is based on information prior to the last order.
Sustained.
When in 2024 did you gain any information about how often he worked at Busby?
He texted me for a little bit in 2024, and we communicated via text, and he said he was
Was
working
that-
at Busby.
Was that after May? Was that after April 24 of 2024?
Objection to leading.
I don't know. I could look it up if you want me to.
Okay. What other sources of income, to your knowledge, does Mr. Jukes have?
Currently,
Correct.
I have no idea.
Right? Because he didn't answer that in his interrogatories, did he?
Objection to
never.
the leading.
Sustained. Don't lead.
You asked, what information did you see regarding his employment in your interrogatories?
I believe he turned in only bank statements from 2023 or 2024.
Objection, non-responsive.
Sustained.
In your interrogatories, what were you asking for regarding his employers?
Their names, I mean, I don't remember.
Okay. And he didn't answer that, did he?
No.
Counsel, what was your last question? You just ran out of time. I have a question, really quickly, Attorney Rewalk. How is your client wanting the court to find him as intentionally underemployed if she doesn't have any personal knowledge of what his income has been within the last year?
Because based on the documents that they've provided, they're claiming that his income is now at the most the amount that he made in 2024 just from Busby. Whereas in the past, as he stated, he's made up to $20,000 on the side doing other things. And now he's not doing those things. He's provided no information regarding this health problem, his lack of work. Again, we got no information whatsoever for the entire year of 2025. He was making that money before, and he's not now. He can, he just isn't.
And Judge, if I can add just one thing.
Go ahead.
Their allegations of underemployment or voluntarily underemployment just came to being about a week ago when they amended their answer. Had they served discovery or looked into the matter, we would have explained that. But I think it's disingenuous to come to court, amend your answer at the last minute and say we did not produce any documents regarding that answer.
May I respond, Your Honor?
No, I don't need the back and forth. Attorney Dale?
Ms. Little, what kind of health insurance does Holland have right now?
Medicaid.
That's something that you enrolled the child in at some point in the past?
Yeah. Yes, sir.
Do you have access to private health insurance at this time?
I don't.
Are you employed?
I am self-employed.
Pass the witness.
All right, Attorney O'Vera, you have 40 seconds left.
I will save my 40 seconds, Judge.
Okay. Attorney Dale?
No further questions, Judge.
Okay. Does the state have a recommendation?
Well, Judge, we'd ask Mother continue to maintain the child on government health, and we'd ask that the cash medical, I think it's at $225 right now, be reduced to $150 a month, which would in turn increase the child support a little bit, based on whatever income's used. So $150 for medical, Judge. The state has no income for Mr. Jukes either. So the state would request that it remain the amount in the temporary order.
Okay. Is that all from the state?
Yes.
Thank you. Attorney O'Vera, would you like to go ahead and close?
Yes, Judge, just briefly.
Go ahead.
In the temporary orders, Mr. Jukes' child support was adjusted to $1,025 per month, Judge. That was based on his testimony of earning approximately $100,000 a year. We are asking the court to continue that. If the court is not inclined to reduce his child support to $862, the $862 is based on $90,000 in a year, Judge, giving him credit for the $225 in the medical support.
Okay. Attorney O'Vera, your client, I understand he just moved to Australia in October of this year, so last month.
No, he moved in April, Judge.
Okay, hold on. He started his work in last month, October of 2025.
Yes.
All right. Mr. Jukes, do you have any intentions to do the additional work that you were doing previously while here to earn that additional income?
At some point when I'm able to, yes.
What do you mean when you're able to?
Well, I can't afford to set up what I need to make tools right now, so that'll be later on down the road. But when I'm able to afford to get a shop set up in order to make tools and do that, I will do that later on down the road.
Okay. So just so I'm clear, that is your intention to do that again?
At some point, yes.
How much time are you needing when you say at some point?
I would say within 12 months.
Okay. Is there anything further from the state?
No, Your Honor.
All right. So the court is going to deny the request to modify the child support. The child support will remain as set at $1,472 under the temporary order.
The temporary order, Judge, is $1,025.
I'm sorry, at the I wrote that down wrong. It's the amount that's under the temporary order.
Okay.
That's going to continue. Based on Dad's testimony, it's his intention to start that extra money within the year. So it really wouldn't be in the best interest of the children to reduce it to $862 when his income is going to go right back up.
Okay. Judge, the medical support, is that set at $150 or remaining at $225? The $225, I believe, was set at the time Miss Little had private insurance. Now I believe the child is on Medicaid.
Cash medical. So we're going to do the $150 cash medical. All right, how long will you all need to give me an order? I can set you on the entry docket on December 5th.
That works for me, Judge.
All right, so if you all circulate the order and get it in to me, send it to Brittany before that date, then that date will go away. You know, you don't have to show up. I'll just sign the order and get it back to you.
Okay.
I'm not available on the 5th if there is a hearing needed.
Well, let me ask this question. Why would a hearing be needed for that?
It may not, but if there's any disagreements on the form of the order, then there may be.
Okay, let me see what Judge Lee has available after that. I have the 12th, the following Friday.
That's fine with me, Judge.
That works, Your Honor.
Okay.
Yes.
I have you all on the entry docket for December 12th at 9:30 a.m. Do you all need the Zoom code for Judge Lee?
No, Judge, I have it. Thank you.
Thank you all.
Thank you.
Have a good
Thank you,
day.
Judge.
Thank you, Judge.